Andrew, the other day you mentioned that you think that the Trump E. Jean Carroll litigation is going to, increase litigation against employers. And I wanted to have a couple minutes to talk about that and get your take on it. Why do you think this is going to be an increased hazard for employers, this trial?
Yeah, thanks, Gordon. I look back to uh, when the Me Too movement began and the increased amount of internal workplace complaints of sexual harassment. Uh, there were greater number of lawsuits filed for sexual harassment and sexual discrimination in the workplace. If you're paying attention to social media, and not recommending that anyone needs to spend more time on social media. However, there are a lot of traffic posts and women who are saying, that generation, they didn't speak up, they didn't complain right away. And even though this wasn't a workplace situation, women are bringing up the workplace. And I think it's a big enough case that regardless of how the jury is going to decide that case, that I think you're going to see a renewed focus, in particular with women in the workplace speaking out when they believe that there's a hostile work environment, they are being sexually harassed, others are being sexually harassed. You're going to, I believe, see greater effort by women supporting friends who they hear are in problematic situations in the workplace to speak out. And certainly, as I mentioned, the plaintiff's bar is going to be out there. And now is a time where, depending on the state in which you live, but New York City, New York State, and the Northeast in particular, you're going to have judges and juries that are, going to be ruling or leaning in a certain way. And that's going to drive, I think, what I predict to be a larger number of lawsuits, larger number of workplace investigations.
So it's kind of like this bright lights being shown on this issue, and it's just going to start the conversations going again. Those conversations could lead to litigation, complaints, whatever it may be. So we're talking about employment-related lawsuits. If a woman was, or a man or a woman was harassed in the workplace, how many years goes by before there's kind of like the employer can breathe a sigh of relief and say, oh, I've got safe harbor now. I don't have to worry about what happened 12 years ago.
Depending on the state and the issue, it's really federal or state or city claims. It's up to 3 years.
Okay.
Depending on the circumstances.
Okay.
That's the time frame. In New York and many states, you're legally obligated to provide sexual harassment prevention training to all of your employees. I remember a number of years ago, before it was the law, it was just best practice. I did a sexual harassment prevention program for a hedge fund, maybe about 25, 30 employees. And at the end of the program, time for the employees to ask questions. There was a young woman who raised her hand and asked, how long do I have to sue the company? Literally. The owner wasn't in the room. So afterwards I said, by the way, I'm not sure what's going on, but I think there's a problem that you have. So things come up now in various ways. Listen, we have many clients. Sexual harassment is still going on. It's going on physically in the workplace. It's going on in the remote environment, in social media. Nothing is new there. It's been going on this whole time. I just think now is a time that companies in particular should pay attention to their own culture, make sure that they can check all the boxes for best practices with respect to discrimination, harassment in the workplace, hostile environment type claims in the workplace.
That was going to be kind of my next question. So what are best practices? What are the preventative measures that employers really should be thinking about more than, as you said, just checking the box, oh, we did this training and it's done. So beyond that, what should employers be thinking about?
Yeah, so you should have of course, the annual training, but then I believe you should add management training, particularly middle-level management. Often they're the ones with the emails that are problematic that cause a claim, or they retaliate. There's a situation where they're annoyed about that is protected activity, and they change schedules, they move someone's office, they take action. And so I think it's really important to have all of your managers appropriately trained on recognizing these situations and then what to do and what not to do, when to keep a record of it, when not to keep a record of it, and how to keep a record of it, and how to interact with the HR function. I think that's really important. Having stay interviews and exit interviews, those are often places to hear where there's cultural issues, I'll say, that might lead to an environment that is at risk, more risk than others for these types of situations. Be aware if you're having, now that a lot of companies and employees are back physically for a period of time, if not all 5 days, people are going to conferences, staying overnight, alcohol at firm events, holiday parties again, summer parties. When there's staying overnight among employees or alcohol, you just need to be more aware and pay attention to those situations. Who's going to be there, who's responsible for that on behalf of the company. So those are a couple of different ways that I think you have to pay attention to now a little bit more than before.
And if an employer gets a hint of an allegation, a complaint may be coming down the pike, or there's some noise about something going on, you mentioned earlier that middle management hears those things first. What are the best practices that an employer should be taking if they've got this kind of sense that something is awry?
Yeah, great question, Gordon. You should have a policy in place, a complaint procedure, so that all your middle management or any manager understands there's no such thing as a formal or informal complaint. It's a complaint. Same actions must be taken. And so you need to have that process in place. You need to have the right people who are trained to do the intake and then what to do from there. Whether you're doing an internal investigation, if you're doing an internal investigation, the people conducting that investigation should have been trained in how to conduct an investigation, or you should be working with outside counsel or outside HR consultants who are experts and trained in conducting workplace investigations. The other thing I'll add, best practice, and it's a plug for the insurance industry. There is no company that should not have employment practices liability insurance. It's a must-have. You're crazy not to have it. It's not an expensive insurance, but it can be critically important, because if you do have it and your retention is, let's say, $5,000 or $10,000, ultimately, other than your time and energy and some cultural issues, economically, that's the extent of your cost if you get sued, right?
Right.
Well, that allows you to make different decisions, right? If you want to let someone go, because quite often I have a client, there's a risk that they could sue, and there's a little bit of meat to that claim. We might win on defending it, but we might not. And if you have insurance, then I can give advice and we can make a business decision very different than if you don't.
Yep.
So it's really important to focus. And I'll say Gordon did not ask me to prompt that. So.
Well, I appreciate that plug there. Andrew, it was great having this conversation. I appreciate your time today, and I'm sure that anybody that's watching this is going to have questions in their mind. I'll make sure that your contact info is in the video at the end of it. So thanks very much for being on today.
No, thanks for having me, Gordon.
Great.